Hey, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within the Commonwealth. Draw near, give your attendance, and you shall be heard. Constitute the Commonwealth of Massachusetts. Court is open. Please be seated.
Thank you, and good morning, everybody, and welcome to this session of the Appeals Court for Monday, June 2nd, 2025. Your panel today is me. I'm Greg Massing. To my right is Justice Henry. To my left is Justice Hodgens. And I'm lucky to be sitting with them, and you're lucky to be arguing in front of them. We have one case for today. We originally had three, but now we're down to one. So thank you for coming. As you probably know, rules are pretty simple. 15 minutes per side, no rebuttal. We have read your materials, so you can just jump right into it. It's your time. You're free to use all 15 minutes, but there's no penalty for stopping early. And with that, I will call the first and last case, 24P631, Commonwealth versus Hall.
May it please the Court, good morning, Your Honors. My name is Daniel DiMaria. I represent Rufus Hall. Mr. Hall's motion for required finding of not guilty should have been granted where the evidence was insufficient to prove that he was operating a motor vehicle. The Commonwealth failed to prove it was a motor vehicle and not a motorized bicycle. There's no evidence of the cylinder capacity, which had to exceed 50 cubic centimeters for it to be a motor vehicle. There's no evidence of the transmission type and no evidence.
Just interrupt you, counsel, with a housekeeping matter. I don't see that anyone's provided the body cam footage to the court, but it was introduced into evidence, correct?
It was, Your Honor. I did not think that it was useful, but if the court wants it, I'm happy to file it and send it up. But it was not introduced at this point.
Well, I would find it useful. I mean, I don't know that you can look at a dirt bike and tell the cc's of the engine from looking at it, but I would like to see the...
Yes, Your Honor. I'll make sure the court gets that right away.
So how is the case Commonwealth versus Griswold not controlling? We can talk about whether that case was rightly decided, but I mean, basically it said even though the vehicle there was not a motor vehicle under the definition of motor vehicle, because the traffic laws of the Commonwealth apply, someone could still be convicted under other sections of Chapter 90, including that one was Chapter 90, Section 24, 1A.
So, Your Honor, my first argument is that Griswold was not correctly decided. It was by this court. It was not by the Supreme Judicial Court. My second argument is that there is a difference between negligent operation of a motor vehicle and driving while...
So could you unpack that Griswold was not correctly decided?
Yes, Your Honor. So the statute in question, the motorized bicycle statute, Chapter 90, Section 1B, states that an individual shall be subject to the traffic laws and regulations of the Commonwealth. In my view, operating under the influence is not a traffic law. It's more of a criminal law. There's actually Chapter 89, which is titled Law of the Road, which has many different examples of driving violations, and I would submit that traffic laws does not encompass operating under the influence.
So you'd say traffic laws is limited to signaling and stopping at stop signs and stopping at red lights?
So in Chapter 89, Your Honor, they talk about yielding to emergency vehicles, lane changes, moving your vehicle if it's involved in a crash, one-way laws, marked crosswalks, but I suppose it would include those as well that Your Honor mentioned. Now,
is there a definition anywhere in the general laws of traffic laws? I know there's some of like civil motor vehicle infraction.
Not that I'm aware of, Your Honor. I don't believe there is. I may be mistaken, but I don't think I've come across that term.
Well, failure to stop would have to be included too, right? Because the traffic laws would be pretty meaningless if the police had no ability to stop someone for a violation, right?
That's a good question, Your Honor. I would actually argue that failure to stop is also not a traffic law, that falls under more of a criminal law than a traffic law.
Well, I'm looking at Lopez, which talked about Griswold, and it says, a traffic law or regulation readily can be understood as one that governs how vehicles are operated. Operation, negligent operation. So is that sentence from Lopez also wrong? A traffic law can readily be understood as one that governs how vehicles are operated.
Your Honor, one point I will mention, I have a good point for you. I'll answer it indirectly. I hope that's okay.
That's fine.
The Commonwealth made a big deal about this being a recreational vehicle, not a motor vehicle. Now, in 2010, the recreational vehicle statute was amended to include both operating under the influence as well as reckless operation. And that is, the reckless operation is Chapter 90B, Section 26B, little a, whoever operates a snow vehicle or recreational vehicle recklessly or negligently shall be punished by a fine of not more than $250. And Section 26A of that statute references operating a recreational vehicle while under the influence. And so my argument, Your Honor, is if the legislature had intended for this to apply to motorized bicycles, why would they have OUI and negligent and reckless driving in the RV statute?
But for those amendments, was that meant to apply to using an RV on non-public roads, not on public ways? Right?
It
Because
just
the
says
RV statute says, the one that we have here anyway, says that they're not subject to the traffic laws when they're off-road.
So you're right, Your Honor, it does say if it's being used over unimproved terrain, but the statute I'm speaking about, specifically 26BA, just says whoever operates an RV recklessly or negligently. It doesn't distinguish between a public way or a non-public way. And so my argument would actually be, if the Commonwealth is correct that it is a recreational vehicle, then in that case, Mr. Hall should have been charged under this provision, not under the 24(2)A. And the penalties are different. The wording is quite similar. Actually, in the new version, it's a lot more streamlined and easy to understand. But I would say he was charged and convicted under the wrong provision.
So you had said, I had encouraged you to explain why you thought Griswold was not correctly decided, but I think you had a second point about Griswold, that it was distinguishable. Is that, have we gone into that?
I don't recall, Your Honor.
Okay, well, bottom line is, why should we not follow Griswold? We've covered why you think it was not correctly decided. Is there anything else you want us to know about Griswold?
Just what I mentioned now, that they've added that OUI provision and reckless and negligent in the RV statute, but not in the electrical bicycle statute. And that must be telling. For whatever reason, the legislature said, let's include it here. They did not include it in the other ones. We basically have 3 statutes, and it's only missing from the electrical bicycle one.
Although, go ahead.
Are you saying under this 2010 amendment, if you, I can't remember now, would a bicycle or electric bicycle or motorized bicycle ever fall under the definition of recreational vehicle?
I suppose it easily could, like a mountain bike with a motor, for example. So it certainly could fall under the definition, that definition, Your Honor.
Well, I guess more broadly, if your interpretation of motor vehicle is correct and that the Commonwealth, definitely motor vehicle excludes electric bicycles or motorized bicycles. I guess my question is does any statute prohibit riding an electric bicycle or motorized bicycle dangerously on a public way?
I would say no, Your Honor. We only have that one sentence in Section 1B, the motorized bicycle one, which says, shall be subject to the traffic laws and regulations of the Commonwealth. But in that regard, Your Honor, that statute does have a 30-mile-an-hour speed limit. And so my view is that given that the legislature put a speed limit in, they could have added additional manners of operation.
25, right? I think you misspoke. 30 is the definition, 25 is the speed limit.
Okay, Your Honor, I stand corrected. So yes, 25. And if a person like Mr. Hall had looked at all three statutes, he would have said, well, these things are prohibited for RVs and for motor vehicles, not for motorized bicycles. And so I think the rule of lenity and other principles of statutory construction mentioned in my brief support my position.
Isn't it the heart of what you're saying more akin to an affirmative defense in that the Commonwealth charges motor vehicle in the complaint under both offenses and alleges that, okay, it's designed for propulsion by power other than muscular power, which you would think that, okay, that's enough to get to a jury on that if you produce evidence of that. But if the defendant then comes forward and says, I have something there's an exception to that or exempt from that, in that there's a different means of propulsion involved here. Maybe it's battery powered or something else. Don't you have to put the Commonwealth on notice of that under Rule 14 to say, there's an exemption that applies. This law actually doesn't apply to me.
I don't think so, Your Honor. Motor vehicle is an element of both charges of conviction. And so to me, the Commonwealth had to prove it was a motor vehicle. And so it's not up to Mr. Hall to disprove.
But if it proves that it's constructed and designed for propulsion by power other than muscular power, and you have testimony from the officers saying that they heard the roar of the engine, okay, that seems to be enough right there that it's a two-wheeled motorbike. The roar of the engine, it seems to be propelled by something other than pedal power. That in and of itself would seem to be enough to get to the jury, no?
I mean, and Your Honor, maybe I'm just not understanding your question. I apologize. But it seems to me that the jury was even instructed with the definition of electric bicycle. So this was all in place. So perhaps I just don't understand.
You're right. It was a very fulsome instruction that kind of covered the waterfront.
Yes, Your Honor.
What vehicles could be. But all I'm saying is if the Commonwealth has to prove it's a motor vehicle, and if it's a motor vehicle is defined as a vehicle constructed and designed for propulsion by power other than muscular power, doesn't that in and of itself get you to the jury? And what your argument is, well, there's an exception to that includes electric bicycles and motorized bicycles and so forth. That seems more of an affirmative defense, no? In other words, does the Commonwealth actually have to address every possible type of propulsion and prove that, well, it's not battery powered and it's not this and it's not that, in addition to proving that it's a motor vehicle, that it's propelled by power other than muscular power?
I understand, Your Honor. In my view, the police officer should have been asked more specifics. How fast do you think this thing operated? How fast was he going, in your estimation? What size engine? So I do believe the Commonwealth should have proved it. We may just disagree, Your Honor.
Can we go back to Justice Henry's first question, which is about the video? First of all, does it show whether there are pedals or not?
There are no pedals, Your Honor.
Okay.
Based on my reading of the transcript, the video I don't believe showed pedals either.
And does the video show it in operation, or is it just it's already on the ground when the video starts?
I apologize, Your Honor. I haven't seen it for some months. I do apologize, but I will send it to the court. I'll put it in the mail by FedEx today. You'll have it within a couple of days.
Okay.
And if there are no further questions, that concludes my submissions.
Seeing none, thank you.
Thank you.
Interesting argument. We'll hear from the Commonwealth. And I understand we have a student practitioner today, which you might not be a graduate.
I am, in like 2 weeks. So.
Congratulations.
Good morning, Your Honors. May it please the Court. Lindsay Conkey with ADA Molly Paris, supervising for the Commonwealth, asking this Court to affirm the trial judge's denial of the defendant's motion for required finding of not guilty. So I want to start with saying that it's the Commonwealth's position that this was a dirt bike that was being operated by the defendant. And therefore, this case turns on a straightforward legal principle, which is that under Massachusetts law, a recreational vehicle is a motor vehicle at all times, unless it is being operated off of a public way. So that means that this accident, which occurred on Tremont Street, is definitely on a public way, making the dirt bike a motor vehicle still.
Right, but the problem is, I guess I'll ask you, but
Yep.
I know the answer to this question. Can a dirt bike have a cylinder capacity that's 50 or lower?
I don't know if a dirt bike can. However, in the 90B section 20 that says that a recreational vehicle is a motor vehicle, it doesn't give any technical specifications, requirements such as the motor vehicle. So the Commonwealth isn't arguing that it meets the motor vehicle standard under Chapter 90, Section 1. It's under Chapter 90B, Section 20, where they discuss that a recreational vehicle is a motor vehicle at all times.
What do we do? Because the answer is that a dirt bike can have a cc of an engine of 50 cc's or 40 cc's, and it's common that at least off-road they cannot exceed the speed that's in this definition on, well, Cambridge Street's just a nightmare, but on other city streets, I think they probably could exceed, but nobody put in any evidence of that. So what do we do if a dirt bike can also meet the definition of a motorized bicycle?
Of a motorized bicycle, then I would turn your attention to Griswold, as you already brought up, as well as Dupre, which they clearly said that the legislature intended to make portions of Chapter 90 that were concerned with operation apply to motorized bicycles, because the legislature is intended to protect the public safety. And so it's not necessarily about what is being operated, but where it's being operated and how it's being operated.
So he argues that Griswold was not correctly decided because basically the definition of motor vehicle, which is in both of the statutes that the Commonwealth is proving here, says it does not include the electric bicycle or motorized bicycle, but that, you know, there's this idea of what's a traffic law. So what do you say about whether or not Griswold was correct? I mean, obviously you're going to say Griswold was correctly decided, but can you explain why?
Sure. I would say Griswold is one of our strongest cases, and it was correctly decided. I think you need to look at the statutory intent, which is the public safety. So they have excluded it from the motor vehicle definition, probably because they don't want types of fines and things that are associated with having maybe a suspended license or having, just from my reading all these statutes, no mirrors or license plates, things like that. So that's why I'm separating them between operational charges and sort of situational charges. But when it's an operational thing that is going to impact public safety, then I believe that they were not trying to exclude motorized bicycles from this statute.
Have you seen the video? Do you know where it starts?
I have not seen the video. We tried to get it last week, and unfortunately the clerk had not retained it. So we can certainly see it again. I think my brother counsel said he would get it, but unfortunately I have not.
So he says that in 2010, the recreational standard was amended to include reckless operation and operation under the influence, and that is significant because it tells us that the legislature did not intend previously for those to apply.
Right.
What do you say to that?
That wasn't raised below, and it wasn't briefed, so this is the first time I'm hearing about that. But I would say that that could potentially be an additional charge that the Commonwealth could have brought, but it doesn't negate the fact that the defendant met all the elements for the 24-2A charge that he was convicted of.
Speaking of things that aren't briefed, what do we do with the fact that, I mean, it seems like there's a way we could affirm this would be to say, Griswold, Section 91B, that it doesn't matter that this wasn't a motor vehicle because motorized bicycles are also subject to the traffic laws. Mm-hmm. But that's not how the case was tried. case was tried, it is charged as a motor vehicle, and it was tried as a motor vehicle. So what do we do with that?
Well, again, the Commonwealth still contends that it was a dirt bike. However, I would say that on review, the review is de novo, and so we just need to make sure that there's enough evidence that a reasonable person could find that.
So but what is the significance that it's a dirt bike?
That it's a dirt bike. If it's a dirt bike, then it falls under that 9DB Section 20 that says that a recreational vehicle, when on a public way, is a motor vehicle. Sorry, it's actually written in the reverse, so I have to, but.
So is there, again, is to encourage housekeeping, because our job's hard enough without uncertainty. So is the defendant correct that the Commonwealth did not introduce any evidence about the cylinder capacity, whether this was an automatic transmission or the speed? That's a compound question, but it's all in the definition of
Correct. No, I don't believe
non-pedaled
that's-
motorized bicycle.
Yeah, I don't believe there's anything on the record about those. There was testimony that it sounded like a motorcycle, I believe, from the officers, the roar, and it was moving in the public lane of traffic, but no, there's nothing about that. I will say briefly, just because Justice Hodgens, you brought it up with the jury instruction, that was really the only time that the motorized bicycle word or phrase was used at trial, and even if the jury received that, it was still a harmless error where the Commonwealth, their case was based on it being a dirt bike, and the likelihood of convicting on that theory was de minimis because there was no evidence presented that it was a motorized bicycle. If there's no further questions, the Commonwealth will rest on its brief.
Well,
Oh, yeah.
I wanted to ask you about, you attempt to distinguish Saldega because you seem to think that the speed was not a factor in the court's holding, and I didn't understand that because it seemed like the court's decision was very clear that there was a second issue.
I don't know that speed wasn't an issue. I would say it wasn't the only issue. The additional issue was the location of the ATV, and that is how I think that it is similar to this case. So there was an ATV that was being driven on a highway. One would probably expect to be going faster on a highway than on Tremont Street, so I'm not sure that that is the dispositive factor there.
Right, but it says our analysis does not stop with the public way, and it talks about, at least at that time, that the statute exempted those motor vehicles that could not exceed 12 miles per hour, and it says this guy was doing 60 on the ATV. That seemed like an important part of the court's holding.
It certainly could be an important part. I think the Commonwealth's argument is that it's not the only part, and it's certainly not the part that was determinative there.
I think at some point the defendant cites an SJC decision that does not seem to be aware, because it was in 1874, the subtleties of all of this. And the SJC says that the definition of motor vehicle really only includes vehicles designed for regular use in the transportation of persons and properties on the traveled part of public highways. And even a dirt bike wouldn't meet that definition. So what do we do with Hein Werner versus Jackson Industry?
I'm not familiar with that case. However, based on what you just said, I can say that certainly things have changed significantly since 1974. I'm not sure that dirt bikes were used as frequently then. I think that they are very common now, especially in downtown, mopeds, dirt bikes, things like that. So I'm not sure that that case can control, especially not with, Griswold and Dupre and those cases that we've had since then.
Well, I mean, the defendant cites the case in his reply brief, and he's using it for the proposition that beyond doubt, that's a quote from the case, it includes that Chapter 90, Section 1 includes only the vehicles which are designed for regular use, blah, blah, blah.
Right. Well, that seems like that would be contradictory to 9DB Section 20 that says that a recreational vehicle is a motor vehicle. And I believe that any future legislations would supersede something that came from 74, but I could be incorrect there. The Commonwealth would ask that you affirm the trial judge's decision and will rest on its brief. Thank you.
Okay, well, thank you both. Well briefed, well argued, really interesting case, and it's submitted. And that will conclude today's session of the appeals court in this courthouse. I want to thank the clerk, the court officers, and we'll be in recess.